So someone fires the one person whose registration number is legally embedded in a $500 million bond agreement. You would think that is the kind of detail someone might check before handing a woman her box on the day she walks back from chemotherapy, but that would require reading the documents. And reading was not really this guy's thing. Stay to the end for my take, and I need yours in the comments. I have a theory about buildings that were built in the 80s. They hold heat wrong. Something about the insulation or the ductwork, or maybe just the stubbornness of architecture that was designed before anyone cared about airflow. The Kessler-Whitman building in Oak Forest, Illinois, was one of those. A 3-story brown brick office park off Cicero Avenue, where the second floor was always 4 degrees warmer than the first, and the third floor smelled faintly of the coffee shop that had closed in the lobby 6 years ago. I spent 19 years in that building, Senior Managing Director of Public Finance, which sounds impressive until you realize what it actually meant on a Tuesday morning. It meant I was the person who knew that the Village of Crestwood sewer revenue bonds had a rate covenant that was reset every April, and that the bond trustee at First Midwest would only accept the compliance filing if it came from my desk because we have been doing it that way since 2007, and Gerald Meyer did not like surprises. Gerald was 67 years old and had been the bond trustee on our municipal accounts for 15 years. He called me every third Thursday to confirm filing timelines, not the firm. Me. My MSRB registration number. That is the Municipal Securities Rulemaking Board, the federal body that regulates every person who touches a municipal bond, was written into the continuing disclosure agreement on our largest active issuance, a $500 million revenue bond for a regional water authority. My number, my name, my fiduciary obligation. I kept a compliance calendar on a shared drive that nobody else ever opened, 47 filing deadlines across 11 active issuances, color-coded by urgency, cross-referenced with covenant trigger dates. I updated it every Monday morning before the coffee kicked in. I called it the Doomsday Book, because if you missed what was in it, Doomsday was approximately what followed. Nobody laughed when I named it that. Municipal finance people are not known for their comedy. Mondays were filings. Tuesdays were client calls. Wednesdays, I reviewed covenant compliance for anything due in the next 90 days. Thursdays were Gerald. Fridays, I did the work that piled up while I was doing Mondays through Thursdays. That was my life, and I was good at it, and I liked the specific, small-scale precision of it. Some people want to run the world. I wanted to make sure page 47 of a bond indenture matched page 12 of a disclosure agreement, and that nobody ended up in front of the SEC because a decimal was wrong. Then in March, the company announced a new head of strategic growth. I was in the kitchen refilling my water bottle when I heard the name. Bradley Kessler, as in Kessler, as in the name on the building. He walked past my office that first week like it was a supply closet. Bradley's first all-hands was a Thursday. He had a slide deck. 22 slides. I know because I counted them while he talked. The way you count ceiling tiles during a meeting that has nothing to do with you. He introduced every division head by name. He thanked the operations team by name. He mentioned the marketing coordinator who had organized the meeting by name. He did not mention me. He did not mention public finance at all. 22 slides. 0 references to the division that generated 34% of the firm's annual revenue. Afterward, Denise from compliance caught my eye across the room. She raised both eyebrows. I shrugged. Some people forget things. But Bradley did not forget things. He curated them. 2 weeks later, he walked into my office without knocking, which, fine, doors are open. But mine had been closed because I was on a call with the Water Authority's CFO about a covenant amendment. I held up one finger. He sat down anyway. When I hung up, he said, "Marisol, I have been looking at the advisory workflow, and I think there is a huge opportunity to productize the client engagement model. These high-touch relationships, they do not scale." I looked at him. He was wearing a vest, not a suit vest, a Patagonia vest over a button-down, in a building where the partners still wore ties on Mondays. I said, "The advisory relationship on a municipal bond issuance is not a product. MSRB Rule G17 requires a named fiduciary with a registered obligation to the issuer. That is a legal designation tied to an individual. It cannot be productized because it is not a product." He nodded slowly. He wrote something on his notepad. I could read it upside down, because 19 years in meetings teaches you that. It said, "Look into this." He never looked into it. What he did instead was reassign both of my junior analysts to a firm-wide rebranding initiative he called Project Catalyst. He CC'd me on an email to his father recommending that public finance be evaluated for sunset potential. He used that phrase, sunset potential. Like my division was a feature on a discontinued app, the email went to 4 people. I was CC'd, not addressed. Denise forwarded it to me a second time with a note that said only, "Are you seeing this?" I was seeing it. 3 weeks before my scheduled chemotherapy, I had told HR in January. I had told my direct reports in February. I had told my clients personally, because that is what you do. When Gerald Meyer has known you for 15 years and deserves to hear it from you, Bradley called a meeting with the bond trustee team. Gerald was on the video call. So was the Water Authority's deputy counsel. So was I. Bradley pulled up a slide that showed my compliance documentation process and said, "This is what I mean by legacy overhead. We have got one person manually tracking filing dates in a spreadsheet when this could be automated and centralized." Gerald's face went still, not angry, still. The way a man who has been doing this for 40 years goes still when someone who has been doing it for 4 months says something so wrong it does not even have a shape he can argue with. I watched Gerald look at me. I watched him understand something about the future of this firm that Bradley's father probably should have explained to Bradley before giving him the keys. Gerald said, "Marisol, we will talk Thursday." That was it. That was all he said. Bradley smiled like the meeting had gone well. I came back from chemo on a Tuesday. 6 weeks. I had lost 9 pounds, and my hair was thinner, and I was wearing long sleeves in July because the port bruise on my arm was still deep purple. I still had the hospital bracelet on. I had not gotten around to cutting it off yet. Or maybe I had not wanted to. It felt like proof of something, like a receipt for time served. Bradley's assistant, a young woman named Colleen who used to bring me coffee when I worked late, was standing outside his office when I got to the second floor. She saw me, looked at the bracelet, and turned her body 45 degrees away. Not a full turn, just enough to not be facing me. You remember angles like that? The geometry of someone who knows what is about to happen and has chosen their position. Bradley's door was open. He waved me in. Marisol, have a seat. So, during the transition period, we completed a strategic realignment of advisory capacity. The board approved a restructure that consolidates your function into the broader client strategy team. Your role, as it was scoped, has been eliminated. He said it the way you would read a parking ticket. Factual, administrative. The hospital bracelet was 6 inches from his face. He did not look at it once. I said, I understand. He blinked. He had expected something else. An argument. A reminder of my tenure. Something he could respond to with another slide about scalability. Okay, he said. Great. Colleen has the separation paperwork. I packed one box. My mug. The chipped one that said, World's Most Adequate Employee, a gift from Denise. A framed photo of my daughter at her college graduation. My personal notebook. I did not pack the Doomsday Book. It was on the shared drive, where it had always been, where nobody had ever opened it. I walked through the lobby, the same lobby that used to have a coffee shop. I could still smell it somehow, that ghost of old espresso that buildings like this never let go of. In the parking lot, I sat in my car for 4 minutes. I know because I watched the clock on the dashboard. 4 minutes of sitting in the July heat, in a building shadow, with a hospital bracelet and a chipped mug and 19 years of knowing exactly which page, of which document would detonate if nobody filed it on time. Then I drove home and made dinner. So she is gone. The bracelet, the box, the parking lot, and somewhere on a shared drive nobody has opened, there is a calendar full of deadlines counting down to 0. Subscribe now, because what happens next is the kind of slow-motion catastrophe that keeps me up at night. The first 30 days were actually quiet. I know because Denise called me every Friday like clockwork, and for the first 4 Fridays she said the same thing. Nothing is on fire yet. I spent those weeks doing nothing. Real nothing. The kind of nothing where you sit on your back porch in Oak Forest in August and watch the neighbor's kid try to skateboard down a driveway that is clearly too steep for him, and you think about absolutely 0 bond covenants while drinking iced tea that you made yourself because you have time now. I read 3 novels. I reorganized my garage. I let my daughter convince me to try yoga, which I hated, but I went twice because she was so pleased about it. Day 41. Denise called on a Tuesday instead of a Friday. The Water Authority's office just called. They said they sent something to your desk, some kind of annual disclosure packet, and it bounced back. Who is handling the filing? Nobody, I said. Silence. Then Denise said a word I will not repeat here and hung up. Day 58. The continuing disclosure filing deadline on the $500 million revenue bond passed without submission. This is not paperwork. Under SEC Rule 15, C2-12, a missed continuing disclosure triggers a material event notice. The bond trustee, Gerald, is legally required to flag it. Gerald flagged it. Day 63. The Water Authority's General Counsel called the bank and asked to speak with the registered municipal advisor on the account. Colleen transferred the call to Bradley. Bradley told the General Counsel that the advisory function had been transitioned to a scalable model. the general counsel asked for the name of the registered advisor on the continuing disclosure agreement. Bradley said he would get back to them. He could not get back to them because the name on the agreement was mine, and my MSRB registration transferred with me when I left. The firm did not have another registered municipal advisor in public finance. They had not had one in 19 years. They had only ever needed one. Me. Day 71. The bond trustee issued a formal notice of potential covenant violation. A cross-default clause linked the Water Authority bond to two smaller issuances. Both were now under review. The rating agencies sent letters. I heard about this one through a former colleague at another bank who called to say, "Marisol, is it true Kessler Whitman missed a 15C2-12 filing on the Water Authority deal?" I was repotting a tomato plant when he called. My hands were covered in dirt. I said I was not sure what was happening there anymore and asked him how his kids were doing. Day 79, Denise called again. She was whispering. Bradley hired a consultant. The consultant looked at the Doomsday Book, called it, and I am quoting, a masterpiece of compliance architecture, and told them they need approximately 90 days and a registered advisor to unwind the exposure. Bradley asked if the consultant could register. The consultant laughed. I almost said something. I had the sentence ready. Tell them to check page 47 of the indenture. The cure period is 30 days from notice. It was instinct. 19 years of instinct. The words were in my throat. I swallowed them. Denise, I have to go. My tomatoes need me. The Water Authority's general counsel was named Patricia Okonkwo. I had worked with her for 9 years. She called me on day 84. Marisol, we need an independent municipal advisor who knows this bond inside out. Frankly, we need one whose registration number already appears in our disclosure agreements. Are you available? I was available. I set my rate at 3 times what the bank had been paying me. Patricia did not blink. 2 weeks later, I walked into a conference room at a law firm in downtown Chicago. Neutral ground. The Water Authority on one side. Kessler Whitman on the other. I sat with Patricia. Bradley was there. So was his father, Richard Kessler, out of semi-retirement. Bradley was wearing the Patagonia vest. His father was wearing a suit. Bradley said, Marisol, I think we can find an efficient path forward here. The transition created some gaps, but the fundamentals are strong, and we are committed to the continuing disclosure filing under Rule 15. C2-12 was due October 15th, I said. It was not filed. The bond trustee issued a notice of potential covenant default on November 4th. The cross-default provision in Section 9.2 of the indenture was triggered on November 11th, placing 2 additional issuances totaling $140 million under technical review. Your firm has no registered municipal advisor authorized to execute filings on behalf of this issuer. The room was very quiet. The compliance calendar that was referred to as legacy overhead was the sole tracking mechanism for 47 filing deadlines across 11 active issuances. It was not documentation. It was the operational infrastructure preventing a regulatory event that could unwind every active bond your firm holds with this issuer, and 6 others. Richard Kessler looked at his son, not the way a father looks at a child who has made a mistake. The way a senior partner looks at a liability. Bradley started to speak. I think what we are dealing with is really a process gap that... Bradley, his father said at once. Bradley stopped talking. Here is what I did not fully understand until Patricia's team completed their review. 3 of those filings contained covenant certification language I had personally negotiated with Gerald over a decade. Language that gave the Water Authority favorable rate reset terms that existed nowhere else in the current template. When I was terminated, those negotiated terms became unmonitored. If the cure period lapsed, without a registered advisor recertifying, the Water Authority would lose rate provisions worth approximately $12 million over the life of the bond. That was not a filing. That was money. Bradley attempted to suggest the situation represented an opportunity to modernize the partnership framework. Patricia said, "We are not here to modernize anything. We are here because your firm failed a fiduciary obligation. Marisol, please walk us through the remediation timeline." I did. Calmly. Thoroughly. Bradley sat through the rest without speaking. He kept touching his vest zipper. Up and down. The tiny sound of it was the loudest thing in the room. I work for myself now. Independent municipal advisory, registered, and sole proprietor. My office is a spare bedroom in my house in Oak Forest. The tomatoes are on the windowsill. They are doing better than expected. The Water Authority retained me on a 3-year contract. 2 other municipal issuers followed within 6 months. Both former Kessler-Whitman clients, both of whom had heard what happened and decided they wanted their advisor to be a person, not a scalable engagement model. Kessler-Whitman settled with the SEC for a mid-6-figure penalty. Not catastrophic. But the reputational damage in municipal finance is quiet and permanent. Issuers talk, bond counsel talks, trustees talk. Gerald Meyer moved the trustee relationship to a competing bank. He calls me every 3rd Thursday. Same as always. Richard Kessler addressed the board in January. Bradley was reassigned to an internal strategy role. No direct reports. No client contact. No division. His LinkedIn still says, Head of Strategic Growth. Nobody has asked him to change it because nobody is looking. Some people have asked me if I would have helped if they had called before the filing deadline. If Bradley himself had called and asked me to walk him through the calendar. I think about that. I do. 19 years is a long time, and instinct is a real thing. I almost answered Denise's question that day on the phone. Almost gave them the page number that would have solved it. But he fired me while I was still wearing the hospital bracelet. And he did not look at it once, so no. I would not have answered the phone. Well, here is my take. The thing that gets me is not the bond, not the SEC, not even the $12 million in rate provisions sitting there like a landmine. It's the vest. The Patagonia vest in a room full of people who built something real over 40 years. And this guy shows up dressed like he's about to grab an oat milk latte and disrupt the municipal bond market before lunch. He looked at a compliance calendar holding together $500 million in legal obligations and called it overhead, legacy overhead. That is the moment you know this guy has no idea what anything costs because he's never built anything that could break. Then he fired the only person who knew where the load-bearing walls were, and while she was still wearing a hospital bracelet. And that zipper on that vest was doing a lot of work in that conference room. So here's what I want to know. She said she would not have answered the phone even if it was to prevent the whole thing. Was she right? Or did 19 years of building that system mean she owed the clients a heads up regardless of who fired her? Tell me in the comments because I know you have opinions. Next video is on the screen. Tap it. And if you're not subscribed yet, come on now, it's time for you to become compliant and fix that.